applied. But now see what happens. If you look at the CO, it applies part 3. That is volume 3. You get it at volume 3, page
14.
Page 14.
Yes.
Volume 3, page 14. But you bring in Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of removable property, 3, settlement in the state, leave aside scholarships. So though part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19,
14.
and 16(1). Then you are taking away the right to acquire removable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e). Right. Those the Constitution expressly made the provisions of Article 19 applicable, which would include these 3 rights, and Article 16. By enacting 35A, you virtually took away the fundamental rights.
I will read 2 state policies, one placed before the Constituent Assembly by the State Department, and the other the speech of Sardar Patel, where they spelled out the policy. This was a departure from that policy. And departures are not permanent. Can never be permanent. The policy is states, that is the Indian states and the British provinces under the Government of India Act should be brought at par, at equal level. That was the policy. And placed in October and November 49, just before the adoption of 370. So 370 was a departure being made because of circumstances, political pulls and pressures and so, and the circumstances which I narrated. So therefore, you have to therefore consider this as a continuing process which was meant to be terminated, and 75 years is a pretty long time for federalizing Jammu and Kashmir at par with other states. That means that the power was rightly vested in the president and was properly exercised by them. It was not that in 1957, one may ask, not that if my contention is accepted, then immediately after dissolution of JKCA, the president could have terminated. Yes, he could. It's a high political policy. It's an act of state. There were some states where forces were sent. That can't be questioned, that how Hyderabad was brought, how Junagadh was brought in, how a referendum was done. All those things are in the past and they were act of state. Mr. Sibal said that had there been another route, act
of state is executive, right?
So executive, nothing prevents the Constituent Assembly from putting a power in the Constitution itself. So that, it is, what was expected was that the Constituent Assembly, when it sits, it might well take a decision that please align us at par. Keep also one more aspect in mind. The framers of the Constitution knew that a President of India is a continuing office. It will not lapse after any point of time. Whether it is part of basic structure or not. But even if it is not, nobody expected that the President of India office, high office in which the executive power vests, will vanish. So it was a continuing power. They also knew that Jammu Kashmir Constituent Assembly is an ephemeral institution. So they had 2 institutions, one permanent, one ephemeral. They are being brought into a relationship in 373 with a notwithstanding. So now not an ephemeral expiry of an ephemeral institution impacts the permanent institution of the president, that can never happen, my lords. Your lips are pursed and we don't want to speak about the truth. Who was the Supreme Commander, my lord, of the armed forces? Auchinleck. All the three generals of India were British. All the three generals of Pakistan were British. What was this war, my lords? Churchill had, my lord, designed there itself that India has to be partitioned. Geopolitics. This war was a British war. They created it on both sides. The raiders came from where? Northwest Frontier Province. After 2 terms, Mr. Cunningham, who had been governor in Northwest Frontier Province, he was brought back in July, just before the elections, referendum. The raiders were trained, sent on trucks with weapons of army. Pakistan army had just been split from India. And the biggest, starkest example is, Lord, who was fighting, Lord? What is this POK today? 2/3 of POK is Gilgit-Baltistan. And who fought the war there, Lord? Not the raiders. It was Major Brown, who was the regent there. He was posted again in July, just before that, by Cunningham. And this is a book, Lord, Mutiny. He killed all the forces of Maharaja. Ansar Ahmad was posted there, Lord, and he was arrested. And in 4 days, Lord, he hung the flag of Pakistan and he had handed over to Cunningham. He sent some Mr. Alam from Pakistan army and he took over Gilgit-Baltistan. Where is the war with Pakistan? It is British. But if we close our eyes to all these, then it is the raiders fighting across borders. Raiders could not by themselves come up to Srinagar. The war had reached almost this Kardu and Kargil and to that closeness to Tibet, Leh. So it was a war of a different kind, but nobody could say it because Mountbatten was there, Lord, as the Governor General. Again, our leaders must maybe having some reason that even though Lord Jinnah said, I will not accept any British Governor General, but the party said, no, we are ready to accept Governor, you continue with Indian Governor General. So what is this war? Governor General, and not only this, when the war began, Lord, they constituted a defense committee of the cabinet. And Mountbatten was made the chairman of that. So it's an excellent situation. Lord Mountbatten is the chairman of defense committee. Auchinleck is the supreme commander of forces. All generals are British and one Britisher is mutinying. And when he returns to England, he is given the medal of the British Empire. So that's not the position of the war. So when you read the Constitution and 370, please bear in mind these things, Lord, in what circumstances our leaders were moving through. And when we were, Lord, about to push them back, Lord, and recover the territory, they deliberately stopped the war at a point of time and got the reference to the United Nations. Because if you had gone up to Mirpur and behind, then that connection would have been off with Gilgit-Baltistan. Now, these are hard facts, Lord. Nobody can dispute it. It is in these circumstances, Lord, and what was United Nations? The same very power which for geopolitical reasons the US and UK which wanted to partition India, they were the arbiters. Fortunately for us, Lord, Pakistan refused to vacate POK. So that resolution is dead. There's no need talking about United Nations, but at that time, look at the enormity of the situation. in which 370 has been.
Lord, it says, I am a responsible and dutiful citizen. I have exercised my right to approach this court. I reiterate the oath taken while being sworn in as a member of Parliament.
Preserve and uphold the provisions of the Constitution of India and to protect the territorial integrity of India.
But this is not rebuttal, Lord. This is adding insult to injury to the nation.
We'll analyze what is there in the.
Kindly, my lord, say something about it. I leave it at that.
Say what?
Your lordship have
3 pages.
One of the requests for
Well,
three.
we must end it with a vote of
Next
thanks
time,
to all the
Your
members of the
lordships
bar.
may-
Thank you very
Your
much.
lordships may read what is not written. Your lordships may read what is not written.
Lord, we thank you, Lordship.
Thank you very much.
Applied. But now see what happens. If you look at the CO, it applies part 3. That is volume 3. You get it at volume 3, page 14. Page 14. Yes. Volume 3, page 14. But you bring in Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of removable property, 3, settlement in the state, leave aside scholarships. So though part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19, 14, and 16(1). Then you are taking away the right to acquire removable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e). Right? Those Constitution expressly made the provisions of Article 19 applicable, which will include these 3 rights, and Article 16. By enacting 35A, you virtually took away the fundamental rights.
Lord, it says, I am a responsible and dutiful citizen. I have exercised my right to approach this court. I reiterate the oath taken while being sworn in as a member of Parliament.
Preserve and uphold the provisions of the Constitution of India and to protect the territorial integrity of India.
But this is not rebuttal, Lord. This is adding insult to injury to the nation.
We'll analyze what is there in the.
Kindly, my lord, say something about it. I leave it at that.
Say what?
Your lordship have
3 pages.
One of the requests for
Well,
three.
we must end it with a vote of
Next
thanks
time,
to all the members
Your
of the
lordships
bar.
may-
Thank you very
Your
much.
lordships may read what is not written. Your lordships may read what is not written.
Lord, we thank you, Lordship.
Thank you very much.
This is my explanation. Learn it.
Look, I just want to know whether your lordships are taking into account these facts, because whether that's extremely relevant from our point of view. Because if your lordships had said earlier that subsequent facts will not be taken into account, we are dealing with the law, we are dealing with these facts.
Mr. Sibal, these facts on what they have said would have possibly no bearing on the constitutional issue which has been argued.
But even otherwise,
But-
because we have to counter those facts, Mullah.
We had asked them a question on the roadmap for holding an election.
That's fine, Mullah.
That's what they have responded.
But Mullah,
That's what, my lord, in my argument
has-
was met.
But our decision on the constitutional issue has to be on constitutional.
but Mullah, these facts will go into the mind of the court because they are trying to show as to how this enormous change has taken place for the benefit of the people of Jammu and Kashmir. If you have 5,000 people under house arrest and 144 throughout the state, there can be no ban. So, Mullah, my request to your lordships is, please don't enter into this arena, because we will have to counter it with all kinds of facts, Mullah, which I don't think is necessary for this court.
The nature of the development work which the government says has taken place post August 2019, this may not be of relevance to your constitutional challenge. And therefore, when they respond to the constitutional challenge, that has to be dealt with independent.
I didn't rely upon it
But,
while
Mullah,
answering on
these
merit.
facts, if they come into your lordships, Mullah, part of the record, then that has.
I think, Mr. Sibal, what the solicitor, to be fair to the solicitor, what the solicitor was saying is that the roadmap to full statehood would take a little time.
That's obvious.
Right now, that they are the development. There, his submission is that right now development work is taking place. Some stability has to be brought about.
This is not a permanent arrangement, namely the UT status. They envisage that it will be a movement from UT to statehood again. We can't give you a fixed point of time when we will restore statehood, but they have told us the process which they are following on the path to.
I have no objection to
That-
that statement. I have no objection.
And that's how we read it.
Yes,
actually.
well, if any other fact that you bring to your lordship's notice has no bearing, because I'll have to count.
Mr. Solicitor, Mr. Attorney, we take it that what you said, Solicitor, a short while back, is along the lines what we said.
Yes, yes,
That
but
this is-
answer the election and
The roadmap
statehood
to-
query, not as a
Correct. I have
justification
no
for.
problems to that.
And Mr.
Mullah.
Sybil also fairly says that he has no difficulty about that.
But-
During my
But
arguments
that
on merits,
this
I
is
never
happened.
relied
This
upon.
this cannot be an answer to the constitutional challenge.
But even otherwise, it should
I
not
also,
be
Mullah,
into your
think,
lordship's
I
mind,
would-
Mullah, that these are great things that are happening, Mullah, because today the kind of drugs that are happening with the youth in Jammu Kashmir is unbelievable. But I don't want to enter into that
Can
controversy.
I put it like this?
The
Neither,
unemployment rate is enormous.
Mr. Sybil, these are matters on which there can be and should be in a democracy policy differences,
That's right.
but that can't affect the constitutional
Absolutely.
answer to a
Therefore,
constitutional
Mullah,
challenge.
once you start placing these facts and Mullah, your lordship.
But therefore, we place those facts which he mentioned in the perspective of the roadmap to statehood. That's all, and nothing on.
This is
on
not
the-
a justification.
This is not a justification. It is, cannot be, from our perspective also, to the answer to the constitutional challenge. We'll have to address the constitutional
So your
challenge. on
lordship will
constitutional
allow me
grounds.
to face some counterfacts to that?
may I put it like this?
Necessary,
Well,
Mr.
I had intervened that stage also when you were saying, only for this reason that we wanted in a conspectus to understand when they look towards restoration of statehood.
No
To
problem.
which they made a statement that
That's no issue, Mullah. They say that will take some time. Your lordships will decide on that issue, Mullah.
And that's confined to our answer, our question to Mr.
But
Solicitor.
Buns
are
have
very
been
clear
reduced to
on this.
zero, buns have
Neither-
been reduced to zero, all that,
Don't
but
mind.
with respect, I say your lordship should not even, those facts are not relevant for the purposes of your lordship's decision is all that I
And
say.
therefore, we had not taken that additional
Right.
affidavit which was sought to be filed at the inception of the record. And I don't think there's been any change in that.
Thank you.
position.
I think it's better understood like this. Neither these statements nor their refutation, if need be, will enter into the question of determining the constitutional validity.
Correct.
So therefore, paraphrase it like that.
Yeah.
We don't want to put it like
And
that.
on that
Kindly
aspect,
speak.
I also
on
didn't
that-
rely.
On that,
Kindly
Mr.
speak.
Sybil, Mr.
It's for an
Attorney and
entirely
Mr.
different
Solicitor,
purpose.
I think there's a broad-based understanding on both sides that the constitutional challenge has to be answered on. a
But
During my assistance on merits, I never relied upon
The
this.
problem is the following, these are televised, all this is being televised and all of this being recorded. So Mullah, these facts come on the record, they are part of the public space and people feel what a great thing has been done by the government. Mullah, this creates a problem. Mullah, that's why I.
What's why progress never creates problem.
I'm sorry.
Lack
Please
of
allow me.
Offenses
All right,
do
Mr.
not
Sybil, we
create
get the
me.
point. We got your point. I think we have clarified it,
Yes.
that the constitutional challenge will be dealt with by the Supreme Court on constitutional grounds.
That's right. None of this should Mullah enter into the.
And they have not argued equity in defense to your constitutional challenge.
That's all, Mullah, that's all.
Yes.
I suppose these statements are otherwise in the public domain. In elections,
There's a
will
lot
be-
in the public
Mr.
domain.
And therefore,
Mr.
Attorney,
public
there's a
will
lot-
consume it.
Mr. Attorney General, you're meeting the constitutional challenge on constitutional argument.
Which I
We
did.
must
I never-
address this matter like any other constitutional
That's
matter as a
right, that's right. In the
constitutional issue
public-
which we have to
I
confront.
There's a lot of facts.
But when I answer the question of election and the statehood, these figures will go into our
So
decision.
that you may, that's not part of the public space.
And that
You-
Mr.
you-
Sybil has also clarified, there can't be any.
That's internal.
We needn't labor this issue. We are all now clear
Yes, yes.
on conceptual grounds. Mr. Attorney, now we'll hear you.
Please, Your Lordship. And one is reminded of Dworkin's very deep engagement in the hard cases and not one single.
Only
Yes,
one
yes, yes.
interruption, Murad, on the lighter side. My learned friend said that there are some people who are under house arrest and therefore there is no bond. Well, that means the right people are in the house arrest.
5,000 people. Let's not make
Isn't
a,
it that?
let's make a mockery of democracy.
People are under house arrest.
5,000 people were under house arrest at that time. 144 was throughout the state. This court, Manadina judgment has recognized that. Well, the internet was shut down and then they are saying there were no buns. Why? How can there be buns when people can't even go to hospital? People could not go to hospital because of the
I
budget.
wish-
Died.
I wish
Let's not go into all
I,
Mr.
I
Sibal,
wish we don't enter into
one
this
second.
dialogue.
Mr. Attorney,
I,
Mr. Sibal, we have, right from the inception of the hearing, we have heard this matter in a sense of dispassionateness,
absolutely.
the sense of objectivity which must govern an answer to a constitutional challenge. We request both sides. Let's maintain it at that level.
Absolutely.
Because, yes. Yes,
I don't
Mr.
think
Attorney.
neither the solicitor nor me has entered into the domain to try to color the mind of the judges. We've not done that.
All right. Yes, Mr. Attorney.
As I say that the famous principle versus rules and the hard cases thesis to Dworkin. One wonders we are not in a situation like this. We're taking off from what where I left day 4 yesterday. There's a couple of